My name is Alan Dillingham. I serve as the Government Relations Director for the Builders, a chapter of the AGC. The focus of today's webinar is on Missouri's Proposition A and its impact on the construction industry. We have partnered with the Heavy Constructors Association, MCA, NECA, and SMACNA to provide this forum for our members. Welcome to you all today. We all recognize the significant repercussions that Prop A will have on your businesses and the industry as a whole. It's a vitally important time that the industry be informed on this, and this webinar is a means to that end. The November ballot measure passed with around 57%, just a little over, of voters approving statewide. Basically, the measure will enable Missouri workers to accrue 1 hour of paid sick leave for every 30 hours worked, and we'll also raise the state's minimum wage to $15 an hour by 2026. For the construction industry, many questions exist, hence today's webinar. We have structured today's webinar around our specific industry and to hopefully answer many of your questions and provide some guidance moving forward. To give you an example, the direct hourly cost of Proposition A is around 3.33%, so 3.33% of an employee's hourly wages and the fringe benefits combined. While there's more details buried in Prop A that'll impact the final calculations, the basic back of the napkin math to calculate the approximate cost per hour is to take the employee's combined hourly wage rate and fringe benefits and divide it by 30. There'll also be indirect costs associated with the administration of Prop A, which will vary by employer. In Jefferson City, there are a lot of moving pieces with this issue. The Missouri Chambers filed a lawsuit to nullify the entire statute. That hearing is scheduled for March 12th. Also, there are bills that have been filed in the Missouri General Assembly to delay or alter the sick leave provisions specifically. So before we jump into the webinar, I just want to offer a few housekeeping items. First of all, please remain muted during the presentation. Second of all, please use the chat feature to send your questions as you think about them. And then we're going to have a Q&A at the end that will go through all of those. And then last, we'll be recording this webinar. And so we'll share the recording and the presentation slides afterward in an email. We are fortunate today to have Erin Schilling and Elizabeth Berg from the good friends of ours, Polsinelli Law Firm, presenting today. Erin provides advice, counsel, and peace of mind so employers can focus on what they do best is operating their businesses. She draws on prior experience in the human resources field to provide training and advice to employers on compliance with various state and federal statutes, including Title VII, the Fair Labor Standards Act, affirmative action laws, and in particular, leave issues. Elizabeth focuses her practice on a variety of employment-related matters. She is committed to understanding the industry in which clients operate and provides valuable counsel to employers as they face sensitive workplace issues. Working closely with fellow Polsinelli attorneys in the Labor and Employment Department, Elizabeth advises clients and provides support during the litigation process. I know that we have a lot to cover today, so Erin and Elizabeth, I'll turn it over to you for the presentation. Welcome.
Thank you, Alan. Appreciate the introduction. As Alan said, I'm Erin Schilling. I sit in our Kansas City office in our advice and investigations group. I serve as kind of outside general employment counsel to my clients and spend my time doing really a variety of just day-to-day answering questions, a heavy focus on executive employment agreements, onboarding and offboarding. And then I have worked with federal contractors extensively on their obligations with affirmative action, which has most recently shifted to focusing on diversity and what to do about diversity in organizations. I'm going to let Elizabeth speak briefly about herself.
Hi, good morning, everyone. My name is Elizabeth Berg. I'm an associate in the Kansas City office here with Polsinelli. I work with Erin and a variety of other attorneys here on many different employment litigation matters and also help a little bit with advice and investigations on Proposition A and things of that nature. Mostly spend my time doing discrimination work and restrictive covenant work, and I'm very excited to be speaking with you all today.
Yes, we are excited to be here. We've been fielding lots of questions on this subject and are excited to kind of give a collective overview of Proposition A and the requirements that it means for employers.
So just to kick us off and get us started, Alan did a great job of providing some background on Proposition A, but just to reiterate and go through some of the details, Proposition A was passed in November, and it passed with a 57.6% majority. The language of the proposition modifies already existing Missouri law. It increases minimum wage and requires employers to provide Missouri employees with earned paid sick time. And throughout this presentation, when you see EPST, we're referring to earned paid sick time just to make it a little easier to read with an abbreviation there, as it can be quite the mouthful. We're going to spend most of our time today on earned paid sick time, but just to briefly cover the minimum wage increase that Proposition A has. It starts in January 1st, 2025, which already has passed. We're at $13.75 per hour right now. On January 1st, 2026, that minimum wage will then increase to $15 per hour. And the proposition's language also calls for regular increases in the future. So we're looking at an annual adjustment that's going to be based on the cost of living reflected in the Consumer Price Index. This is a price index published by the Department of Labor. And so the minimum wage will increase or decrease depending on what happens. Likely, though, it will just continue to increase. As for sick leave, employees will begin accruing earned paid sick time on May 1st, 2025. Like Alan mentioned, this requires employers to provide 1 hour of earned paid sick time for every 30 hours worked. There is no maximum or cap on accrual, but there are caps on use and carryover, which we will talk a little bit more about in detail. Employers do have the option of front-loading earned paid sick time at the beginning of the year in the amount expected to be accrued for an employee, which can help with some of the having to avoid doing calculations and things of that nature on the back end if you do it at the front end. Employees are permitted to carry over 80 hours of earned paid sick time from year to year, but that does not mean that they're allowed to take 80 hours of sick time each year. If you are a business with 15 or more employees, you can limit employee use to 56 hours of earned paid sick time in a year. If you have less than 15 employees, it's going to be a little bit less than that. We're looking at 40 hours of earned paid sick time in a year. And I will turn it over to Erin to talk a little bit about applicability.
Okay, thank you. It applies to really almost all employers. So employer is defined as any person acting in the interest of an employer in relation to an employee, and a person includes in its definition business, corporation, etc. There are no minimum number of employees tied to the definition of employer. So some laws will only apply if, for example, an employer has 6 employees or 15 employees or 50. There's no minimum here. So it applies to all employer. There are some limited exceptions tied to the government, so it would not apply in those situations. An employee is any individual employed in Missouri by an employer. There are very limited exceptions to who might not rise to the level of employee. I would say overall, the exceptions are all tied to very casual relationships. It lists out stuff like a casual or intermittent golf caddy or newsboy, someone who works in a private residence on a casual basis for less than 6 hours per occasion, casual babysitting, retail or service business that has an annual gross volume of less than $500, someone who's incarcerated, foster parent. So very, very limited exceptions to the definition of employee. I think probably one of the big shifts for many of our clients is that it's going to apply to full, part-time, and temporary employees. So often paid leave is limited to full-time employees, and that's not the case with this law. There's also going to be no waiting period for when an employee is covered. So we, again, often see a time period where paid leave might not be available initially in an employment relationship. So maybe after the first 90 days, someone can start to take leave or something along those lines. This applies from day one. So the accrual starts on day one. You'd have the option of either front loading or just starting the accrual process on day one. One of the questions that we've faced often is what happens when we have an employee who works in multiple states. This is not specifically addressed in the law on what happens there. But our interpretation is it does say any individual employed in Missouri, suggesting that it only applies when an employee is working in Missouri. So if you have an employee who spends part of their time in Missouri, part of their time in Kansas, part of their time in Oklahoma, whatever the situation is, they would get the hours during the time that they're working in Missouri. Now, this is a subject that we're hoping will be more fully addressed in future guidance. We are hopeful that there'll be some regulations and some guidance that will flesh out the law in more detail. But that is our initial interpretation. One other interpretation that does exist is if the employee's primary home base work location is Missouri, that they would get the hours. And let's say they were working from a facility in Kansas most of the time, but they worked out in the field in different states, including Missouri. Maybe there's an argument that it doesn't apply then, but I think it probably applies every time that they're working in Missouri. Okay. All right, our next subject that we're going to talk about is what it means for an exempt versus a non-exempt employee. The law does specifically set out that for someone who's exempt, we can just assume they work 40 hours a week. So let's say you have an exempt employee who's often working much more than 40 hours. You don't necessarily have to give them more time. We can just assume the 40 hours. And it also provides a carve out that if you have someone who's part-time, you could use a lower number as that exempt employee's calculation number. So we would look to what is their normal work week, and we could come up with, they normally work 30 hours a week. So they're getting that person would get 1 hour per week, either front loaded at the beginning of the year or accrued throughout the year. And if an employer has 15 or more employees, the 1 hour, and they work 40, and that person works 40 hours a week, that would come out to 69.33 hours per year, or rounded up to 70 per year if we weren't using the 0.33. For someone who is non-exempt, they would get 1 hour for every 30 hours worked. You could front load them. If you were going to front load, you would base that on what they were expected to accrue at the beginning of the year. So we would again encourage you to look at what is their normal work week to determine what they were expected to accrue at the beginning of the year. The law does not address what happens if, at the beginning of the year, we're expecting, in general, a 40-hour work week every week, and something shifts in the business and they're working 50 hours pretty consistently. It does not address what would happen in that situation. Probably the fair thing would be to add some additional leave to someone if their regular schedule changed during the year, and that would certainly be the more conservative approach. That would again be something that we would hope to get future guidance on under the law. And then on carryover. So while they accrue 1 hour per 30 hours worked, or are front loaded that amount at the beginning of the year, they are capped on their use per year. I think Elizabeth already touched on this, but it's an important concept that I think is a little bit confusing. So while they might accrue that's 69 hours per year, they can only use, if you have 15 or more employees, they can only use 56 hours in a year. And if you have under 15 employees, they can only use 40 hours in a year. So they could potentially have accrued more hours in a year than they're able to use if they work full time. And they are allowed to carry over up to 80 hours per year. So for example, if you have someone who accrues, let's say the 40 hours per week, so they accrue 70 hours per year and they used, let's say the 56, they'd have an additional 14 hours that they could roll over and carry over to the next year. So they would have, I think the point is that they would have some hours to start with at the beginning of the year and wouldn't have to start at 0. You do have an alternative under the law. You could pay out the accrued hours at the end of the year that were not used, up to 80. That would be a choice. So if you have that person that had the 14 hours left, you could pay out the 14 hours. If you do that though, you are required to front load them the next year. So if you're using an accrual method, it doesn't make sense to pay out at the end of the year. If you were using a front load method, perhaps that interests you. I would say most employers are not interested in the payout at the end of the year. They would prefer just to allow the employee to carry over those additional 14 hours and they have them sitting there. They'd again continue to accrue throughout the year. So let's say at the end of the next year, again, they were a full-time employee and they accrue another 70. So they accrue 70 hours. They had 14 left over. They would only, though, be able to roll over 80 of those hours. So they would lose 4 had they not used any. Let's say they, in our example, they had not used any. Again, point being that they would have some hours in the bank. But if they do not use the hours, then they would eventually start to lose hours each year because they'd only be able to carry over the 80 hours.
And as Alan mentioned, there is a legal challenge pending right now for Proposition A. So some Missouri business groups have filed a lawsuit in an attempt to invalidate Proposition A. For a little bit of background, the case number is at the top, and we've also provided a resource page at the end that includes a link to the full complaint if you'd like to read it. So this was filed on December 6th by these various business groups. The business groups are essentially asking that Proposition A be declared invalid. They argue a variety of things, but some of the main things they argue is that the proposition itself is unconstitutional. Missouri ballots per the Missouri Constitution can only contain one subject. They are arguing that minimum wage and earned paid sick time are 2 different subjects. And so the ballot was not valid. They also are arguing that the summary statement was both insufficient and unfair, and similarly situated entities are treated differently in violation of the 14th Amendment of the United States Constitution. So they are taking this from a variety of angles. This is pending before the Missouri Supreme Court. And so we are waiting to see what they end up deciding and how that will play out. One of our colleagues wrote a great blog post about the legal challenge. If you want to read a little bit more into it, the title of the blog is there. And when we circulate the slides, it will include a link as well. So in terms of reasons why an employee can use earned paid sick time, there's a couple different buckets that they fall into. The first one is going to be personal care. So that's going to be the employee themselves. So a mental or physical illness, injury, a health condition, basically what you normally think of when you think of sick time. You know, you have a bad cold, you have COVID, you go to the doctor, etc. You might need a medical diagnosis, care, or treatment of a mental or physical illness, injury, or health condition. So, you know, like I said, you're going to the doctor because you're sick. And so any kind of preventative medical care also falls under that. So any kind of just employee taking care of themselves mentally, physically, that's going to qualify. There's also language in the law that allows for care of a family member. So this is going to be a similar situation where it's a care of a family member with a mental or physical illness, injury, or health condition. Maybe you need to take the family member to the doctor or to see a specialist, or they need preventative medical care. That's going to fall under the statute as well for being able to take earned paid sick time. There's also certain carve-outs for public health. I would not be surprised if a lot of it's because of related to COVID and closures with that. So anytime there's a closure of an employee's place of business due to a public health emergency, maybe you have a child whose school or place of care, like a daycare, has been closed due to a public health emergency, that's going to qualify as well. You might need to care for a family member or oneself if, you know, a healthcare provider determines that the presence in the community may jeopardize the health of others. Maybe there's, you know, a mumps outbreak in the house, something like that, where it's going to be a little bit more of a public safety risk. There's also a domestic violence, sexual assault, and stalking carve out. So these absences can be a little bit broader than just, you know, sick or having to seek medical care. This is when an employee or a family member needs to seek that medical attention. And this can be for physical or psychological injury related to the domestic violence. They might need to be seeking services from a victim services organization, so it does not have to just be a medical provider here. They can be seeking psychological or other counseling, so things like therapy. They might need to be relocating to a safer home or to a shelter that is going to qualify for taking earned paid sick time, or if they need to seek legal services because they're seeking something like a protective order or they have court orders against their abuser, those kinds of situations will fall within earned paid sick time. And Erin's going to talk a little bit about union considerations.
Okay, we've gotten lots of questions on this subject as well. So first of all, let's touch on the collective bargaining agreement. So even if you have an agreement in place with the union that provides a certain amount of leave, you are still going to have to comply with the statute. So let's say your collective bargaining agreement provides for some lesser amount than what's provided under the statute. You would still need to provide additional leave in compliance with the statute. For the reasons that Elizabeth just went through. So it's not for just anything, but assuming it meets one of the 4 prongs of leave that's allowed under the statute, you would need to provide that leave. When it is time to bargain, you would want to bargain on this topic to put into your collective bargaining agreement the type of or leave that matches with what's provided under the statute, at least something that is at least as generous as what's provided under the statute. We're going to talk as a later topic, we're going to talk about policy options, and this kind of overlaps, but you could have one leave bank that meets the requirements so maybe it provides for vacation leave and PTO leave as long as it meets the requirements of the statute, that's fine. You could have 2 leave banks where you have leave that meets the statutory requirements, and then you have another type of leave that could be used for vacation or other purposes that does not meet the statutory requirements. And we'll talk about the pros and cons of each approach. We are also hopeful that we'll get some more direction and guidance on this subject going forward. But for now, the statute is pretty silent on what does it mean for. It is silent. It does not address, whether a collective bargaining agreement has any impact on the requirements of the statute. And we are hopeful that they'll give us a little bit more there going forward. One other subject that I think will be a hot topic with union employees is the rehire. If someone is rehired within 9 months of a termination, then their balance needs to be reinstated. So practically, if you're hiring from a union hall sporadically throughout the year, and it's within 9 months, they're going to keep a balance going throughout that time. Now, if you pass the 9-month mark, you would again start over. But if you hire someone month 1 and month 3 and month 5 and month 7 of the year, they're going to continue to keep a balance going with your organization. And then the other thing is just to keep in mind that they need to earn from day 1 of their employment. So even if you hire them on a short-term project, they would accrue some paid leave from the start. So you hire them for 1 week, they work 30 hours, they're going to have 1 hour that they accrue that week.
So a little bit about documentation in terms of requesting using earned paid sick time that they've accrued or you front loaded, and also what you as an employer can ask your employee to give you if they take earned paid sick time to prove that they took earned paid sick time or to know how long their absence is going to be. So starting a little bit with the requesting for using it. An employer can request to take an employee, can request to take earned paid sick time verbally in writing, by electronic means, whether that's a system that maybe the employer has to request an absence, or by other means that is acceptable to the employer. If you have in your policy, or it's known that, you know, an employee can text and be like, hey, I'm sick today, that would likely be acceptable under the statute if it's been acceptable in the past. If possible, the request should include the duration of the absence, but it is not necessarily required. As we all know, sometimes it's not foreseeable how long we're going to be out sick. An employee must make a good faith effort to provide notice in advance if the earned paid sick time is foreseeable. Maybe they are, you know, sick the night before, and so they would provide that notice that night that they're not going to be at work in the morning because, you know, they have a cold or what have you. However, there is a carve out in the statute that if the need is not foreseeable, an employer can require an employee to provide notice just as soon as practicable. We don't have a firm definition of what that is. It seems like it's probably going to be on a case-by-case basis, whether or not they informed you as soon as practicable. As for maintaining a written policy for this kind of request, if an employer does require notice of the need to use earned paid sick time, if the need is not foreseeable, that not as soon as practicable caveat that we're talking about, the employer has to provide a written policy with procedures for the employee to follow to provide that notice. An employer cannot deny earned paid sick time based on non-compliance with said policy if a copy of that written policy is not provided to the employee. So if you're really firm on how earned paid sick time needs to be requested, if it's a spontaneous or, you know, emergency situation, you need to have a written policy in place, and we can help you with that if necessary. An important couple of things to remember: you cannot, as an employer, require that the employee search for or find a replacement worker to cover the hours during which the employee is using earned paid sick time as a condition of taking that earned paid sick time. So you cannot say that you can only take earned paid sick time if you have someone to cover your shift. The statute does not allow that. An employer also cannot require disclosure of details about employee or family members' health information, domestic violence, sexual assault, or stalking information as a condition of providing earned paid sick time, just as a little bit of, you know, protection for the employee, that they don't have to give their employer all of their personal health information or the private information of their family members. If you are taking,
I'm going to pause there, but we would need to know enough that it fits in the category, one of the categories. So we need to have some basic information, but it doesn't give you free range to ask every detail.
Thank you, Erin. If you're taking earned paid sick time over 3 consecutive days, an employer can require reasonable documentation that the earned paid sick time, kind of what Erin was just talking about, is being used for a covered statutory purpose. So those purposes we talked about earlier, care for family members, seeking medical or preventative care, that's going to be something like where you have a doctor's note indicating that the earned paid sick time is necessary. So again, this doctor's note is not going to have all the nature of the illness, all the health needs, all the details, and you can't ask for that, but you can absolutely ask for a doctor's note saying, you know, so-and-so was out sick today, came and see me, please excuse them from work. For cases of domestic violence, sexual assault, and stalking, reasonable documentation might look a little bit different than just a traditional doctor's note. So this can be a police report, a written statement from an employee or agent of a victim service provider, a signed document from a healthcare professional. That's going to be your more standard doctor's note. They can also be a court document saying that they were maybe in court because of a situation that involved domestic violence. What's interesting is the statute does also allow a written statement, basically from the employee affirming use of earned paid sick time for the purpose of caring for themselves or their family members involved in a domestic violence situation. So that one is a little bit more flexible than the traditional sick time.
All right, we are going to shift gears and, as promised, talked about some of the options that you have with a policy. And so when we talk about these options, this would be options you'd also have under the CBA, depending on what you would like to do. So first up, we're going to touch on the idea of a combined PTO policy. So many employers have shifted to the combined PTO policy several years ago. At one time, we had separate sick and we had separate vacation, and we shifted to the idea of a combined PTO policy. And there were reasons to take that approach. It was maybe administratively easier. We didn't have to worry about slicing and dicing like what the leave is for this time and what policy we're under. The statute does specifically allow for you to continue to use the idea of a combined PTO policy, as long as the leave that you're providing is as broad and for the topics as covered under the statute. So if you are providing enough leave, or like, let's say you're providing a smaller amount, but you just bump it up so that they can get the requisite number of hours. So an equivalent to 1 hour per every 30 worked under the leave law, you could continue to use your PTO policy if that was something that you wanted to do. And for some employers, that taking that approach may be easier because they don't have to provide a separate additional bucket. And maybe it's easier to have the one bucket. The drawback of this approach is a couple things. First of all, the sick leave that we're discussing today never has to be paid out on termination. So, you know, they may have accrued 80 hours in their bucket, they term, you don't have to pay out. And under Kansas and Missouri law, you could have by policy a requirement that you don't pay out anyways. That's an option, but in some states, payouts required. So if you have employees in a state where payouts required, you may not want to bump up the bucket of PTO to a higher number because you're going to have to pay it out on separation if you have it in this combined policy. Whereas if you had it in separate and you had a small PTO policy here and you had over here your paid sick time, you would pay out the PTO, but you would not have to pay out the additional paid sick time that's sitting over there with termination. The other drawback is that sick leave only has to be given for the qualifying reasons, and you can, under PTO, you could say like you could only take PTO during a time that works for the business. If it's foreseeable, you could kind of direct that, whereas paid sick time, you really can't direct the timing of the leave. So that would be another drawback. If you combined it into one, that would get a little bit murky. The other drawback would be that if you have employees working outside of Missouri and you're bumping up your PTO bucket for all, you are, you know, in theory, offering more leave to everyone. You could have a Missouri only PTO policy, and then you could have a, you know, like let's say a Kansas only PTO policy. That would be an option that you could take. Okay, next slide. Okay, and then there's the idea if you have two separate buckets. So you have a PTO bucket, and then you have a paid sick leave policy bucket over here. The pros of this type of approach is the paid sick time has to be available for accrual on day one of employment, but you could have PTO have a waiting period tied to it. So they could start to accrue on day one for their sick. And PTO could be delayed a time period, like let's say a 90-day introductory period. That would be an option. If you had it in combined, it's going to have to be available on day one, at least an amount as generous as the 1 hour per every 30 worked. The paid sick time applies to all employees. We talked about that. If you have it separate, you'd have that paid sick leave policy that applies to everyone. PTO could be limited. So oftentimes we see PTO limited to just full-time employees, and that would be perfectly acceptable if you kept the buckets separate. If you had a one combined bucket, then you'd have the paid time available to everyone under the policy. We already talked about this on the flip side, but the paid sick time does not require payout upon separation. So again, we'd have that benefit upon separation. We wouldn't have to pay out even if it was accrued. And even if you were in a state that did require payout on separation, it would not require payout of paid sick time. If you have it separate, it may be a little bit easier to have a Missouri only policy. You could still do it the other way, but you could have just a paid Missouri sick time policy that only applies to your Missouri employees or employees working in Missouri. And then we also talked about this but the paid sick time only has to be given for the qualified reasons. PTO could be limited to times that are convenient for the company. The cons of the two separate buckets is you would have to check each source each time potentially. Potentially someone could take some leave that would qualify as paid sick time or under PTO. So you may need to look at both buckets. And then you may need to, for business reasons, decrease the amount of PTO you have in the bucket to make room for the paid sick time. And perhaps that's not a good move from an employee relations standpoint to decrease PTO to allow for that sick leave bucket. And then of course, another con would be if you, I'm sorry, you would also have the option of just increasing the additional leave time on the PTO bucket if you wanted to keep it as combined as one. Okay, and now we're going to kind of shift gears to kind of a potpourri of several different topics under the statute, and we're kind of going to rapid fire through those, and then we'll shift to your questions at the end.
So starting with record keeping, employers under the statute are required to retain records documenting hours worked by employees and earned paid sick time that is taken by employees for a period of at least 3 years. This is so that the Department of Labor and Industrial Relations can be allowed access to these records to monitor compliance with the statute's requirements should they want to. The director may inspect these records by appointment with the employer. If these records are kept outside of Missouri, maybe your headquarters isn't in Missouri or you're located outside of Missouri, they must be made available upon demand. So you might have to kind of bring them over state lines if you're on the Kansas side. Records and information are considered confidential under the statute, and they can only be disclosed if a court of competent jurisdiction orders it. So basically, unless absent court order, you shouldn't really be sharing these documents that you're maintaining to comply with the Department of Labor and Industrial Relations requirements. If you as an employer have any health or safety information regarding an employee or an employee's family member, since they might be taking earned paid sick time either for themselves or for care of a family member like we discussed, that information is considered separate and it must be maintained in a separate form and file from other personnel info. So you want to do your best not to kind of muddle those two together if you have any private health or safety information. The statute requires that these records be treated as confidential medical records, and they are not to be disclosed except to the affected employee or with their express written permission. So that way things are not muddled together.
Okay, now we'll kind of talk about some end of employment considerations. If they are transferred to a separate division, entity, etc., within the same company, and they continue to be employed by the same employer, the paid sick time that they have accrued would follow them. We already mentioned if they're rehired within 9 months, then their balance needs to be reinstated. If there is a sale of business, accrued sick time transfers to the buyer. And again, that balance stays with the employee. And then there is no payout of accrued time is required on termination of paid sick time.
There is a little bit of a incentive not to keep employees from taking earned paid sick time. Under the statute, it explicitly says that an employer cannot interfere with, restrain, or deny the exercise of the rights afforded to an employee by the proposition's language. This means that an employer can also not take retaliatory personnel action or discriminate against an employee, whether current or former, because the employee has requested or used earned paid sick time in the past or filed a complaint of employer violations of Proposition A. So this is going to kind of be similar to something like a discrimination suit where, if the employee files a charge, you can't retaliate against them for filing that charge. It's going to be kind of a similar idea. Earned paid sick time also cannot count as an absence that may lead to or result in discipline, discharge, demotion, suspension, or another adverse action. So something like a no call, no show, or, leaving work without saying anything, basically abandoning the workday, that's going to count as a different absence than an earned paid sick time absence. The statute also requires that the employee provide written notice on an 8.5 by 11 paper and 14-point font. This has to be provided within 14 calendar days of either commencement of employment or on April 15th, 2025, whichever is later. We anticipate that the DOL will likely put out a form that can be used to give to employees, but we haven't seen that yet. The notice includes some detailed information, but mostly along the lines of giving them information about accrual, so that 1 hour for every 30 hours worked, the prohibition of taking retaliatory action against employees who request the use of the earned paid sick time, explaining the employee's right to bring a civil action if that is denied or they're subject to that retaliatory personnel action, and also the contact information for the Department of Labor and Industrial Relations. Again, we're expecting the Missouri Department of Labor and Industrial Relations to put out a form for this, but we're still waiting to see. In that same vein, there's also a poster requirement that goes along with that. We expect that the Department of Labor and Industrial Relations will be putting out a poster for employers to put up. And that also begins on April 15th, 2025. They must display a poster that contains that same information as the written notice in a conspicuous and accessible place where employees are employed.
Okay, so to kind of wrap up some of the main points that we've covered, you're going to have to decide whether you want to use the accrual or the front loading method of providing the leave. So accrual would be they would earn the leave throughout the year starting May 1. So 1 hour of leave is earned for every 30 hours of work. Alternatively, you could front load the amount that you would expect them to earn based on that same formula. So if they are a full-time employee who usually works 40 hours a week, or if they are exempt salaried employee who works 40 hours a week, they would get the 69.33 hours front loaded. You also need to consider what you want to do with the policy. Do you want to continue to have a combined PTO policy and make sure you expand that policy to cover the requirements of this statute, or do you want to have two separate policies? So you'd have your PTO policy that applies to some situations, and you have your earned paid sick time policy that applies to others. Keep in mind that we have the May 1 effective date. We are, of course, monitoring that legal challenge, and you should be as well. You would not want to implement this or work this into a CBA before May 1 because it does not apply until May 1 and it is still subject to that legal challenge. So we want to keep that in mind, but also, as Elizabeth just covered, we'll have to give some notice a couple weeks before that May 1 deadline. And then we will be watching out for whether there are any regulations or additional guidance that will be forthcoming from the state that would give us more information about the statute and its requirements. And then we're going to shift to questions. I see that we have a few in the chat, which, Ellen, did you want to read those? Or you want me to just read it and answer, or?
Yeah, you can do that. If I could just start with two questions. One, could you clarify that Prop A does not go into effect if a CBA was in place on November 5th until the expiration date of the CBA, or if it's amended, not modified, et cetera? Just to go into that again, please.
So the law applies whether you have a CBA in place or not. So even if you have a CBA that provides a certain amount of leave, you're still covered by the law and have to provide leave that is at least as generous and meets the requirements of the statute.
Okay,
If
thank
I
you.
could jump in for one moment,
Yeah.
Greg Davey with the Builders. There is a provision tucked in the very back of Prop A that does provide that if you have a valid collective bargaining agreement in place as of election day, so November 5th, as Alan mentioned, then the paid sick leave version of Prop A does not go into effect until that CBA expires or is in any way amended, modified, or anything of that nature. So we are going to have some situations coming up where if there are ongoing negotiations this year, say this spring, those trades are going to have those issues to tackle, whereas folks who are still midterm aren't going to have to deal with that until those contracts expire or otherwise modified.
Thank you for providing that clarification, Greg.
Thanks, Greg. Yeah, so anyone, please put any your questions into the chat, and then yeah, Erin and Elizabeth, since you can see them, go ahead and just read them and answer them if you could. That'd be great. Thank you.
Yeah. Okay, so the first question that I see is from Brian. It says, what happens if the sick time is used ahead of accrual and the employee terminates their employment? So first of all, you don't have to allow them to use the sick time ahead of accrual. You could, you do have the option to advance them the sick time. That's a choice you could make under the statute, but you are not required to do so. The statute is silent on what happens if you have advanced a sick leave and then they are terminated before they have accrued that additional leave. You at a minimum would need some sort of written agreement in advance, likely, that would allow you to get repayment on that advanced leave. The next question is from, oh, I'm sorry. You want to go? No? Okay. I see a question from Sabrina. How does Proposition A's sick time accrual requirement apply to salaried employees who do not track their hours? Is there a standard assumption for hours worked, or will employers need to implement a tracking system for compliance? So for a salaried person who does not track their hours, so that under the slides we refer to those as exempt employees. So they're exempt from the overtime requirements. They're exempt from the hour record keeping requirements. You could you would allow them to either accrue or front load hours based on 40 hours a week if they're full-time. If they are less than 40 hours, you could use a lower threshold based on their standard work week. But you could still use either the front loading method or the accrual method for someone who is salaried exempt and does not track their hours.
I can take the next one, Erin, if you'd like. So the next question from Stacy, does the retaliation issue supersede approved apprentice program disciplinary and attendance policies? It kind of depends. So like I had discussed, if there's an absence control policy, so if you're saying that those apprentice program disciplinary and attendance policies have what the statute would consider an absence control policy, where you're allowed to take certain action against the employee for unexcused absences and things like that, yes, it would come into play for that. So the earned paid sick time absence, if taken for a qualified reason, those cannot be counted towards those absence policies that could lead to demotion, discipline, suspension, or any kind of other action taken against the employee on that piece.
Next question says, you say that sick leave applies to all, so even temporary employees like a summer intern. And yes, it likely does apply to your summer intern. There's some very limited exceptions under the statute, but generally a summer intern would not meet those exceptions. Okay, next question. Confirming hours accrual for employers based in Kansas. They will be liable to accrue sick time on hours physically worked in Missouri, even if their business is not in Missouri. So the statute does not specifically address this particular issue. It says that it applies to employees working in Missouri. And so we interpret that to mean that it would apply to anyone who is working in Missouri, even if their home while they were working in Missouri, even if their home work location is located in Kansas. That is a subject that we're hoping to get more clarification on in the future. Elizabeth, do you want to take that next one?
Yes. So, earned paid sick time, whether or not it needs to be paid out if an employee quits or is terminated. The answer is no. It does not need to be paid out whether an employee quits or is terminated. There's nothing stopping you from having that in your policy if that's something you've already been doing. It is not a requirement under the statute.
Okay, so next is, how does the proposition affect government work that also requires paid sick time? So there's nothing in the statute that would require you to provide a separate sick leave that would only apply under Missouri and also have your government sick leave. So they could overlap, just like your existing PTO policy could be in place. It could overlap and you could have one policy that would apply to both. Okay, next question. It will be difficult for a union contractor to track, agree, with the workforce being so transient. How would that be done and or paid out when they are released? So first of all, you would just have to figure out a way to track how you're going to, so you're tracking how many hours they worked. Hopefully you can also, so from there you would track how many hours they accrue. So if you know that they worked 30 hours for you, they're going to have 1 hour, but you do not have to pay it out when they're released. So you don't need to worry about that part, but you just need to keep an accrual of what hours they've worked in the event that you rehire them. Because if you rehire them with 9 months, they get their balance sitting there again. But again, you do not have to worry about the payout upon release.
For the next question, can an employee claim after the fact on a no-call, no-show that it was for personal leave covered under the statute? We're not entirely sure yet. The statute does not say that you cannot do that. And in terms of requesting earned paid sick time, it just says that it shall be upon the request of the employee. So it could be interpreted, though we don't know yet, whether or not that means that after the fact they can say, hey, I was, sick. Maybe I have a doctor's note. So that's one of those sticky points that they're going to have to work out.
Okay, next is, if an employer has a current combined time off policy, it would have to be amended to have the 80-hour rollover. Yes. So any combined policy has to be amended to provide at least as generous benefits to the employee as required under the statute. And that includes the accrual, that includes the rollover, or the front loading, and the reasons for leave that are allowed. It has to be amended to cover all of the requirements of the statute. Okay, next it says, who will settle disputes between the employee and the employer if there is a discrepancy of accrued hours? So I'm not sure the statute addresses this, but generally it's on the employer to keep records of hours worked. The employer has that obligation to keep records of hours worked, and so that's what we would look to. If there is some sort of discrepancy where the employee says they work different hours than the employee, we would go through the same normal channels that you would if you had a discrepancy on pay. So if they said that, we'd have to check our resources, but if we have a timekeeping method, that's generally what we defer to, is the timekeeping that the employer kept.
And to add to that, the statute does say that the department may, though it's not done yet, it may establish and implement a system to receive complaints regarding noncompliance and then investigate to attempt to resolve any disputes. But we're still waiting to learn more about that clause.
Next question is, are fringe benefits paid on earned paid sick time? I don't remember that being addressed, but would assume not, since they're not hours actually worked. Greg, did you have information on that point?
Yeah, this has come up a couple times in our discussions with some of the trades. So the language reads that it includes the same hourly rate with the same benefits, including healthcare benefits, as the employee normally earns during hours worked.
Okay.
So our interpretation of that, from a bargaining perspective, is that that does include fringe benefits as well as the wage.
Perfect. Thank you. Okay, next question is during the accrual process if the employee's carryover grows, so I think that means if the employee's accrued hours is beyond 80, do they keep accruing time? It doesn't say that accrual is capped at 80 hours. It says that carryover is capped at 80 hours. So in theory, they could continue to accrue additional hours beyond 80, but they wouldn't be able to use them because there's a cap on use of 56 hours in a year. And then at the end of the year, they can only roll over the 80. Now, I suppose someone could accrue over 80, use 56, and that still leaves a big balance that they could roll over up to the 80 hours. But there is no cap on accrual. There is just cap on carryover and use. Okay, next is, will there be follow-up communication regarding the outcome of March 12th? I'm not
That's
sure.
on the court hearing. Yeah, we're
Oh.
going to be following that, and we can follow up with that with you all, along with the legislative process too, and what changes might be coming from there.
One final question. It says, and I can see how there's some confusion. Okay, so I think there was a comment that we would not want to work into the CBA before 5/1/25. That's when it is scheduled to take effect, assuming there's no change under the court case. And then there was a comment that the law applies whether we have the CBA or not. And then Greg clarified that if a CBA was in place on the election day, the law doesn't apply until the next CBA. This is all correct. This is all stated correct. For a new CBA that's effective on April 1 of 25, currently being negotiated, should the provisions of the new law be incorporated. So if they were incorporated, you'd want them to not be effective until 5/1. And I think you need some kind of qualifier in there about subject to legal challenge and the change under the law. I suppose alternatively, if it wasn't incorporated, you would not fall in that exception that Greg has reviewed where if you had the CBA already in place. And so if you didn't have it in the CBA, you would still be covered by the law on 5/1, assuming there is no change under the legal challenge that's pending.
And the last question, balances are to be reinstated if an employee is rehired within 9 months of their previous departure. Yes, that is a rehire provision specifically in the statute that says that an employee who's rehired after 9 months of their employment ending will have that previous accrual balance reinstated.
Great. Well, it's 12 o'clock. Thank you so much, Erin and Elizabeth, for all of this. Lots of information. And as with any new law statutes, it's fluid, a lot of moving parts here. People are trying to get their arms around it to understand it, including state governments. So stay tuned and all that. We'll definitely be following that. And please reach out to all of us if you have questions in the meantime. Really appreciate you joining us today and hope you found all this useful. Please enjoy the rest of your day. Thank you.